Good morning, everybody. I want to talk to you real quick about a topic that's actually come up a couple of times recently in my practice, and that is the issue of guardianship for minor children. So here's the situation. Nice family, they got a couple of kids, minor kids, any children under the age of 18 would qualify. And the question then becomes, what happens to those kids if something happens to both mom and dad? And a lot of people think that, well, an aunt or uncle, cousin, an older brother or sister, or a grandpa and grandma can just take the kids, but that's not legally the case. I spoke with a police officer this morning, and he confirmed that, if that he showed up at a situation, let's say mom and dad have gone out to dinner on a date night, and then they get hit and injured, incapacitated, or even killed in a car accident on the way home, let's say. The police respond to the home. The kids are there. They're in the care of a minor babysitter temporarily. Well, the babysitter has to go home. So the police officer I spoke to this morning confirmed that they have to take those kids into custody into Child Protective Services. And that very night, they're going to be with a foster family. And obviously, that's not ideal. That's not what we would want to happen to our kids if something happened to us. We want them in the hands of friends or family, people we know that love them and that are going to want to take care of them. Fortunately, Missouri has given us the ability to do just that under Chapter 475.046. It's Missouri's standby guardianship law. And what that does is if a custodial parent or parents have taken the initiative to draft the appropriate documents ahead of time, you can have documents on hand, that if something does happen to you, your friends or family member can take custody of those children immediately as standby guardians. Now, they have to let the local probate court know within 10 days that they are acting as standby guardians, and within 60 days, someone needs to file a petition for permanent guardianship or long-term guardianship. So there's still some probate cases involved, but those documents are relatively simple. We help people do that for a relatively modest attorney fee, but more important than that, this is really just a piece of the puzzle for families with minor children. There needs to be a good estate plan in place with powers of attorney and potentially a trust even to make sure that all this goes well. And so because of that, we do minor protection planning at no charge for our clients that do full estate plans if they have minor children. So if this is an issue that concerns you, if you have minor children or know someone that does have minor children and you're concerned about the fact that if something happens to those parents, those kids are going to go into foster care until the judge appoints a guardian, which could be months, and you want to do something to make sure that those kids never have to be in Child Protective Services, never have to go to foster care, that they can always be in the home of a friend or family member that you know is going to love them, you know is going to take care of them, then feel free to reach out to us at Worsham Law Firm. Our website is at logroglaw.com. That's lawgaragelaw.com, or you can go to willworshamlaw.com. They both go to the same place. And you can find out more information on how to get in touch with us, how we can help you make sure that there are standby guardian provisions in place through a minor protection planning, and explore all the possibilities of having a really well-rounded, complete estate plan that makes sure nothing's going to slip through the cracks. So that's my tip for the week. This is Will Worsham with Worsham Law Firm, and thanks for listening. I appreciate it.